So we will now hear our colleague, Professor Filippo Annunziata, who will be joining us online. I hope he's already there. So if I may very briefly introduce Professor Filippo Annunziata. He is a professor of financial markets law at the Bocconi University in Milan, Italy. He is also a member of the academic board of the European Banking Institute based in Frankfurt. Professor Annunziata has published several works on alternative finance and crypto assets and is currently a leading scholar in these domains. He will be enlightening us on the licensing principle in the MICAR draft regulation. Professor Annunziata, thank you very much for being with us today, albeit at a distance, and we very much look forward to listening to you. The floor is yours.
Well, thank you very much. I hope you can hear me, but apparently the tests seem to work properly, and that you can also see my presentation. So first of all, thank you very, very much for inviting me to this conference. I would really have loved to be there in presence. I love Lisbon. I have a lot of friends there. But unfortunately, this was in a perfect but tremendous overlap with another major conference that we had in Siena yesterday afternoon and today's morning. And at a certain point, I got caught up with flight schedules, and I couldn't make it to Lisbon. So I will try to do my best by presenting remotely. And as the chairman was rightly anticipating, I'm focusing on how the licensing principle works in MICAR. I will show you very briefly, just a few seconds, this slide, because I will project this slide at the end of my presentation, because this is a sort of a map of how the licensing principle works in the MICAR regulation. You see there are basically 4 different areas where the proposed MICAR regulation deals with licensing rules. On the one side, asset reference tokens such as stablecoins. On the other side, e-money tokens, and then crypto asset service providers and issuers of other crypto assets different from asset reference tokens and e-money tokens. Before I briefly describe how rules on licensing work in MICAR, let me immediately point out something which is a distinctive feature of not just MICAR, but of EU financial regulation and legislation. And this is the idea, the concept that once you are there on the market providing certain kinds of services to market users of any kind, or if you are an issuer of new products on the market, you are required to have a license. This is a guiding principle of EU financial legislation. It's cross-sectoral. It is obviously applied differently from one sector to the other, but it is, I would rather say, the leading principle of EU financial legislation. If you carry out a business which is in some way regulated, you need a license. And MICAR follows this principle, not surprisingly. But obviously, it is raising an issue that apparently will be left outside the current scope of MICAR, as we expect it to be finalized over the next weeks, which is the issue of how do we deal when we do not have a specific identifiable service provider on the market, which is obviously a distinctive feature of distributed ledger technology, decentralized autonomous organizations, and I would rather say also a distinctive feature of the world of crypto assets. Now, this is a question that for the moment doesn't have an answer. So what we end up by having is a MICAR structure that in relation to the licensing principle is, in my view, pretty traditional. There are a couple of peculiar points that I would like to point out in a few minutes, but it's pretty traditional, the approach that MICAR takes to the licensing principle. But at the same time, we have a different market in front of us. It's the first time that we have to deal with things such as decentralized autonomous organizations or truly decentralized DLTs, such as, for instance, Bitcoin. And I don't want to enter here into the debate of what decentralization effectively means, when you can really say that something is truly decentralized, because this is a different story. But naturally, if you miss the center element of an entity that you sort of identify when accessing the market, and you apply to that entity the licensing principle, which again is one of the fundamental principles, or rather the fundamental principles of EU financial regulation, the world changes, and this is something that MICAR is not really considering. So the way in which the licensing rules work under MICAR is a combination of national competent authorities and European banking authorities' competences in terms of giving the license to these entities that will go there on the market and interact with the crypto asset environment. And more specifically, one thing that is immediately necessary to point out is that if you look at the right side of this slide, you see that licensing is pretty much in the line of tradition when you speak about issuers of stablecoins, ARTs, issuers of e-money tokens, and service providers in the crypto asset industry, which is the central sort of part of this slide. And then you also find that MICAR follows an approach which sort of looks at what we have done in the single supervisory mechanism, so that when you have a big entity, a large entity, which is defined as a significant issuer of asset reference tokens or of e-money tokens, then licensing will move from the national level to the European level. And this is the right side of the slide. And you see that in this case, it will be, at least from the current version of MICAR, the European Banking Authority who will provide this license. This also has other implications in terms of the global architecture of financial supervision and regulation in the European Union, because with MICAR, what will happen to EBA is similar to what has already happened to ESMA, because it will be sort of a turning point in the life of EBA that for the first time will be granted with direct licensing and supervisory powers, which is something that we have already seen with ESMA, for instance, in relation to central counterparties or credit rating agencies. But EBA, for the moment, was in a different dimension, acting basically as a regulator rather than a licensing authority. And I think this is a very interesting thing to look at, considering the wider debate on the role and structure of the European supervisory authorities. But then if you look at the left side of this slide, you see that there is something which is peculiar, because if you are an issuer of a crypto asset, which is different from ARTs or EMTs, so any crypto asset that would be labeled under MICAR as a utility token, then you require no authorization at all. And this is a little bit out of the approach, different from the approach that we follow in the closest environment that you can think of in this respect, which is the prospectus regulation. Because in the prospectus regulation, the idea is that anybody who places on the market through a public offering a security, by the way, in that context, we're talking about transferable securities, must publish a prospectus, and the prospectus is filtered, authorized. You know, there are discussions as to the nature of this filter that the prospectus has vis-a-vis the national competent authority. For instance, in Italy, we are pretty confident about the fact, and nobody has ever questioned the fact that the sign-off by the Italian competent authority, which is Consob, for the publication of a prospectus is an administrative authorization, proper authorization, which resembles the idea and the concept of licensing a service provider or an entity providing financial services on the market. But here in MICAR, this area works differently because, as I will point out in a few minutes, the idea is that the market in crypto assets is still small. The principle of subsidiarity probably suggests that we are not yet, or we were not yet, in an area where you really need the national competent authorities to provide authorization in this context. And also MICAR says we don't think that providing a proper authorization in this context is appropriate because it would place an excessive burden on the shoulders of national competent authorities that have to deal with a very new environment, and they will have a lot of other things to look at rather than applying the licensing principle upon the issuer. If you then move into the core of MICAR and see how the licensing principle is applied, it is reminiscent and many times replicates the criteria and the rules that you find in banking law or in the context of investment services regulation or collective investment schemes. So the authorization is granted by the NCA, and if you look at asset reference tokens, this authorization is mandatory. Nobody will be capable or allowed to issue asset reference tokens, such as stable coins, for instance, on the European market without being licensed by a national competent authority. There are a number of exceptions that are in some way looking at applying a principle of proportionality. For instance, there is a threshold of 5 million euros below which you're not required to be licensed as an ART provider, but these are details that do not sort of compromise the basic principle. It's a little bit different for issuers of e-money tokens because here MICAR is sort of grandfathering the licenses that current e-money services providers have on the basis of the e-money directive. And the general rule is that if you issue an e-money token, you must be already authorized as a credit institution or as an e-money institution. So differently from asset reference tokens, you will not be required to have a new authorization. The reason for this is very simple, because you already have an authorization under the e-money directive. But what is interesting here is that regardless the fact that you already have a license as a credit institution or an e-money institution, the issuer of an e-money token will have to comply with the additional requirements that MICAR applies to EMT issuers. And this again is another element of interest, because by what's happening here is that MICAR is sort of gold plating on the existing e-money directive by basically saying if you're an issuer of e-money through a DLT, you use a distributed ledger technology as the underlying technological basis of your electronic money, then you will be subject to general rules coming from the CRD or e-money directive. But in addition to that, so that's where MICAR is gold plating on the existing directives, you will be subject to additional and quite stringent additional requirements and rules that come from MICAR, which in my view contradicts the always cited principle of technological neutrality. I must say that I have never really believed in the existence of this principle, but since it is constantly called upon and cited as one of the guiding principles of the EU technological and financial revolution that we're witnessing, I have to say that this is a clear example of an area where the principle of technological neutrality not only does not exist, but it's openly contradicted, because the simple fact that you are placing on the market a token, which is an e-money instrument, through a distributed ledger technology brings the issuer into a completely different environment, or rather into additional environment that comes from MICAR with very tough rules that will apply on top of the existing legislative framework. And then we come to the significant ARTs and EMTs I don't want to spend more than 10 seconds on this slide because there's obviously a whole body of rules into MICAR that provide definition of what is a significant ART and EMT issuer. But what I would like to point out again here is that if you are a significant issuer because you are below these thresholds, then the licensing will be provided by the European Banking Authority and not by the national competent authority, which leads us back to what I was saying at the beginning in terms of the transformation of the European Banking Authority into a hybrid institution, agency rather, in between regulatory and supervisory functions, similarly to ESMA. And then we are left with issuers of crypto assets different from ARTs and EMTs, and these issuers do not really require any prior authorization. So the licensing principle in this area of MICAR falls apart. It is not applicable because an issuer of a crypto asset, which is a utility token under MICAR, simply has to draft a white paper. Very interesting case here. You see that a European regulation picks up from market practice. White papers were invented by market practice, and it's the market that has inspired and shaped this part of MICAR. So the issuer will draft a crypto asset and will notify this crypto asset to the competent authority, but the competent authority doesn't need to approve, review the white paper before the white paper is actually there, available to the public, and the utility token is placed on the market. And as I anticipated, the main justification for this that MICAR recitals give is that the market is still small on the one side, and we must at least it was small. It's not so small anymore, I guess, but when MICAR was drafted at the beginning, this was one of the justifications. We have to look at how the market develops, but also the second justification is that national competent authorities should not be overburdened with the task of pre-approving or, let's say, licensing the white paper before it is on the market, which is a reasonable approach, but I think this may be an area of weakness of how MICAR will operate, and especially how the passporting principle will operate once MICAR is up and running and will be enforced. And why is this? Because as some of you might be aware, I know that there are a lot of friends and colleagues in Lisbon. I've been receiving messages this morning telling me, can we have a coffee during the break? I said, no, sorry, I'm not in Lisbon, I'm away. But these friends are people with whom I have extensively discussed over the past couple of years. My idea that MICAR is, on the one side, a great opportunity and a really outstanding achievement of the European legislator in the context of crypto assets, but at the same time, it is weak, dangerously weak in terms of taxonomy, definitions, and identification of different kind of crypto assets that would fall under MICAR. And more precisely, the boundary that MICAR sets out between what falls into the scope of the new regulation and what instead already falls under the scope of existing capital markets regulations, such as precisely the prospectus regulation and MiFID, is a little bit shaky. I would rather say quite shaky, because of the problems of taxonomy and definitions that we have not so much in the context of MICAR, but rather in the context of MiFID and prospectus. And this is confirmed by the DLT pilot regime regulation that was approved a couple of weeks ago, where the EU legislator thought that it was absolutely necessary to clarify that financial instruments that are issued on a DLT are still to be considered as proper financial instruments for the purpose of MiFID, which in some way, again, is a little bit strange. I think it's a good idea to clarify that if you issue a share or a bond through a DLT, it is still a share or a bond, and if it is negotiable, it is a financial instrument for MiFID. It's a good idea to clarify that so that nobody has doubts. But it also sort of explains that the principle of technological neutrality is not so strong, because if you need to clarify that a share issued through a DLT is a financial instrument, and you amend the definition of financial instruments under MiFID in order to do that, then I think that you're not so comfortable with the principle of technological neutrality. So what you end up by having is that there will be crypto assets out there on the market that will be difficult to classify. Are they utility tokens, or are they financial instruments or transferable securities? And the regime is completely different at that point, because if it's a transferable security, for instance, it will fall under the prospectus regulation, and the licensing principle applies in that area, as I anticipated. But if it's not, if it is a utility token, then it will fall under MICAR, and the licensing principle will not be applicable, or rather it would work in this sort of gray way where you have the white paper which is notified. But at that point, if you have a crypto asset that's been considered by the national competent authority of a member state as being a utility token and is placed on the market as such, but at that point, that utility token will circulate with a MICAR passport, but it is not to be taken for granted that once that token hits a host country, it is offered, distributed in a host country, the approach to interpreting what that token is exactly the same than the one that you found in the home country. Having said that, I just need to spend 2 words on the licensing of crypto asset service providers. You see on the slide, on the right side, this includes a whole range of service providers. And this is probably the area where you see that the impact of the MiFID regime or the collective investment schemes directives is stronger on MICAR, because the way through which the licensing principle operates in relation to entities who provide services in crypto assets is very, very similar to what we already have. And to conclude, I would like to recall that there is also a grandfathering principle in MICAR, and this is set out by the provision that according to which investment firms and also credit institutions that are authorized under MiFID to provide services that are equivalent to investment services and activities, if they provide services in crypto assets which are equivalent to the investment services, there is a grandfathering rule which is perfectly reasonable that would say you do not need an additional license under MICAR because you are already licensed under MiFID, which is perfectly reasonable. But once again, we have problems, and this is the conclusion of my speech, is that the problem is that the definition of the different kind of services is not exactly the same between MiFID and MICAR, and the slide gives you just an example of what you find, for instance, if you look at the definition of providing advice in crypto assets, which is not the same as the definition in MiFID II. So this grandfathering principle must be, in my opinion, improved and clarified, because it might not work as it is in the intentions of the recitals and of the original idea of MICAR, due to the misalignment of definitions between MiFID and MICAR. So going back to my initial slide, you see there are these 4 areas: ARTs, EMTs, crypto asset providers, and then issuers of non-ART and EMTs, which are really as outside the licensing principle under MICAR, notwithstanding the fact that due to the problems of taxonomy and identifying what is really a utility token, they might be sort of clawed back into the prospectus regime if an issue of qualification of a utility token arises and leads you to the conclusion that that utility token is indeed a transferable security or eventually a financial instrument. Thank you very much for your kind attention, and please accept again my excuses for not being able to be with you in Lisbon.